Good morning, everyone. Good morning, everyone. Today is the fourth session of Law and Sociology, that is SOM 6213 paper. So, in last week, we have discussed in block 3 about the sociology's what is their aspect regarding the laws and sociology. I hope you all have gone through in the last class of SOM 6213 Law and Sociology. So I hope everyone has gone through properly regarding the law and sociology. Okay, if you have gone through the law and sociology, try to take paper of SOM 6213 and also try to go through the studying materials. Because our class is specifically blended with study learning material, the SLM which we have given you, try to please read and focus on the study learning material. So let us see what the blocks for today laws in India gave us. What does you understand by laws in India from a sociological perspective in block 4? So the first topic is regarding the tradition, law and justice. So when we say tradition, law and justice, it's Riti, Niyam and Niyai. So it will try to focus on tradition, law and justice, try to explore the foundation of societal structure. So there are three pillars of society in this aspect of tradition, law and justice. Tradition and law. Tradition encompasses generational customs and beliefs, providing identity and continuity. Law represents formalized rules by governing bodies to maintain order. So the tradition encompasses generational customs and beliefs, providing identity and continuity. Law represents formalized rules by governing bodies to maintain order. So the custom beliefs and beliefs is a very important tool for a especially identity and continuity. And law also represents the formalized rules by governing bodies to maintain order. So tradition and law are interconnected. They uh, they work together in a process that it encompasses the continuity. They two are identical that it forward the continuity. Law represents the formalized rules by governing bodies to maintain order. The next is the principle of justice. Justice embodies fairness, impartiality, and equity. It includes justice procedure. It includes various ways that which a justice can be assessed. So it is very important for a justice. Kindly go through what the points I have given. Try to read it properly. So if you go through the principle of justice, Nyai, justice embodies fairness, impartiality, and equity, includes procedural, fair process, and substantive, equitable outcomes dimension. So this is a very important criteria where it is important. When we talk about the Indian tradition and dharma, the concept of dharma is the guiding principle encompassing duty, righteousness, and moral order in the social fabric. When we see in terms of the Indian uh, Riti Rivas from the history. It is a guiding principle encompassing duty, righteousness, and moral order in social fabric. It dictates familiar roles and ethical conduct. Rooted in ancient civilization and migration, Buddhism acts as a pivotal role in unifying forces. The Varna system reflects historical social structure. So when we talk about the second, child labor and women, when we talk about the laws in India, child labor and women is also the another part of the factor to examining the causes, conditions, and legal protections. So this is a very important dimensions of what to be considered regarding the child labor, and women as well. So when we look at the child labor, the causes and the impact, we have to think about the urban realities, the rural context, and the legal response as well. When we see the child labor, whether which we have seen the employment in BD or METS or fair work industry, there is a high prevalence in dhabas and domestic help, which is required. So we have normally seen in urban in cities and towns that workers are engaged in various activities of what we call it the fair work industries, whether in terms of the BD METS, the high and also the high prevalence in dhabas and domestic help as well. And looking at it now, when we say there is a rural context is like the participation in 3 times higher than urban, focus on cattle grazing and family farms. And legal response as well. Article 24 prohibits hazardous work under 14. The Child Labor Act 1986. Before jumping on the legal response, let us see the rural context as well. The participation in the rural is 3 times higher than for urban. Um, Mainly the child labor who focus on cattle grazing and family farms. So this is the reality what we see in our country. And if we see the article in the legal response aspect, Article 24 prohibits the hazardous work under the age of 14. The Child Labor Act 1986 regulates non-hazardous roles as well. So this child labor, if we see in terms of the three aspect in urban, the rural, and legal also can be seen. Whether we talks about the fair work industries or the dhabas or domestic helps in rural, we can also see is in terms of the cattle grazings and family farms. And we see in the legal response, the Article 20 prohibits, the child labor regulates. Now, if we see the key legislation for women, the Domestic Violence Act, the Domestic Violence Act protection from physical, emotional, and sexual abuse 2005, and Dowry Prohibition Act, eliminating harassment related to dowry demands 1961, Maternity Benefit Act, paid leave and medical benefits for employees. The Workplace Arrangement Act 2013 mandates internal complaints committee. So we need to consider this aspect of important dates and aspect of important form. The Domestic Violence Acts, which we see like 2005, the Dowry Prohibition Act, the Maternity Benefit Act that is established 1961, work arrangement that is 2013. So these are the various factors that have come up in the spin time that which is important for our legislation for women as well. Now, when it comes to inheritance and divorce, to navigate the complexities of civil law, to inheritance and divorce, navigating the complexity of civil law, we need to also see how this inheritance and divorce is established, like the civil law, family matters, the inheritance law or the divorce law, governed by the Indian Succession Act 1925, includes testamentary will and intestate. Testamentary requires legal heirship certificates. Now, we completely cease that with the maternity benefits Act in 1961, or the Dowry Prohibition Act 1961, or the Workplace Harassment Act 2015, or the uh, Domestic Violence Act 2005, have completely also have evolved with the inheritance law, which we have seen in 1925, that include the testamentary will and instead no will. Success requires the legal hardship certificates. So these are very important forms. These are very important forms of thing the inheritance laws have to take up across. Have to take some. Have to take some across. Governed by the Indian Succession Act 1925, includes testamentary will and instate no will succession requires legal hardship certificate. Governed by religion-based personal law, that is Hindu Marriage Act or the Shariat Application Act. Grounds include cruelty, adultery, and sedition. There are certain divorce law which is still in transition to have fight. That are divorce law, will and no will succession requires legal hardship certificates. So when we talk about the juvenile laws in India, the prioritizing rehabilitation over retribution, who are the underage with the adolescents, there's juvenile laws in India as well. The juvenile laws in India, the justice for youth. The juvenile justice system emphasizes the duly incapax, the principle that a child cannot form criminal intent. The focus is on the three core principles: the guidance, the reform, rehabilitation. The guidance, correction over regular court trial; reform, reintegration into society; rehabilitation, non-penal treatment in homes. Non-penal treatment in homes. The guidance, the reform, rehabilitation. So in 2015 Act permits trying 16 to 18 years old as adult for heinous crime. So this is very important act for juvenile. What can we see? So I want you to capture properly of this the justice for youth. What does it talks about? Try to maximize what does these involve. Try to see what does this imply. Go through it for a while, and then I want you to try to understand and discuss.
another.
So if you have gone through it, I want to share you something more regarding the juvenile justice as well. So kindly see your screen. I'm going to share you a video which is very important for you to understand. And after that, I want you to ask what is
I didn't live the best of lives, and we barely got by. Then it all changed when one day I pushed my best friend, like I always did. But I think it was too hard because he fell and he bled. Before I could even react, the red on the ground matched the red flashing around me. I felt a hand on my shoulder and they took me away. This 16-year-old wasn't a child anymore, not to them at least. I was a murderer being locked up, probably because no one heard me cry.
देश में नाबालिग अपराधियों का ड्राफ्ट लगातार तेजी के साथ बढ़ रहा है.
Would one be secured if after 2 or 3 years of some juvenile home they come out on the streets and commit that kind of offence again?
राज्यसभा में आज जुवेनाइल जस्टिस बिल पेश किया जाएगा. विरोधी दलों से संकेत मिल चुके हैं कि आज बिल पास हो जाएगा, यानी अब किसी निर्भया का न्याय अधूरा नहीं होगा.
How would I have reacted? I would have probably taken out a gun and shot the person.
Lowering the age will be a step backwards and a knee-jerk reaction.
It certainly will stop 16-year-olds from going into a thana and saying, मैंने जी झुग्गी को आग लगा दी है, मुझे जेजे में डालो.
Treats children as adults, which is simply wrong, morally, legally, constitutionally, ethically and emotionally.
I think the bill is passed.
But it was very clearly, an immediate response to the kind of media attention that the tragedy of the girl called Nirbhaya, who was raped and murdered in Delhi, provoked. One of our attackers was said to be a juvenile, and there was a lot of bloodlust around. People wanted something that will punish him more than the year and a half or less that he was going to get in a juvenile home.
And I know that some media organizations decided to actively lobby for this law.
So that one hard case was seen as the reason, and certainly supported by big headlines based on wrong facts.
It is quite alarming that you allow laws to change, legislations to change, not on rationale, not on logic, but on emotion.
Of all the 472 million children in our country, a grand total of 1.2% have committed any crimes at all. Of that, something like 3% or so have committed both rape and murder. So you're talking about 3% of 1%. Where are you getting some sort of major crime wave?
We don't know how to handle crime. We don't know how to handle children. And the easiest solutions is to make your laws more punitive.
We are in a situation in which children are being condemned to a life of criminality thanks to this awful bill.
The Juvenile Justice Act, first introduced in 1986, mandated for the separate trial of the child, now referred to as juvenile, for those under the age of 16 for boys and 18 for girls. India then passed the Juvenile Justice Act of 2000 after signing on to the United Nations Conventions of Child Rights in 1992, raising the maximum age of juvenility to 18. It added on to the children in conflict with the law, a child found or alleged to have committed an offense before having turned 18, with the category of children in need of care and protection, those without a stable home or any means of subsistence. Notable cases involving juveniles, such as the Nirbhaya case and the Shakti Mills case, caused an uproar. This led to the 2000 Act being replaced by the Juvenile Justice Care and Protection Act of 2015. The Act categorizes crimes into 3 categories according to the Indian Penal Code. Crimes incurring punishments of up till 3 years are classified as petty offences, 3 to 7 years are classified as serious offences, and punishments of 7 years or beyond are put under heinous offences. Most controversially, children who commit heinous offences in the age group of 16 to 18 years can now potentially be tried as adults. However, the Act strictly mandates that a child cannot be given a maximum sentence of life imprisonment or capital punishment.
There is no reasoning why you believe that a 15-year-old can be reformed and a 17-year-old cannot be reformed?
It's a very logical connotation, because in many other countries, much younger people, age of 14, etc., also treated as adults.
In America, some places hanging कर देता है, 100 साल सजा दे देता है. ऐसे होना चाहिए in our country also.
There is no biological reason for why we draw the universal age line for a child and an adult at 18, right? The closest biological determinant that you can come to is that a child's, a person's prefrontal cortex is usually developed by a certain age. That age usually lies around 25 to 27. It does not lie at 18.
In 2015, when this evidence was produced in the UK courts and the US courts in 2005, which has led to abolition of death penalty, abolition of life imprisonment without parole, abolition of life imprisonment. A lot of changes have happened after that report. So therefore, going to 1995, when US introduced the penal consequences for children in 2015, makes no sense to me.
And of course, it creates a lot of other slippery slopes for the kind of laws which may be laid down with this as precedent also, right? That if you've said that we think you're almost an adult at 16, it's so easy for those boundaries to keep shifting as well.
With the age bar falling lower, juveniles can often be taken for adults and thrust into the criminal system. With improper age determination, that isn't far from reality.
The Juvenile Justice Act itself says how the age is to be determined. They're saying first you go by the obvious appearance and then go by any certificate which they have, whether from an educational institution or from a panchayat or a municipality and so on. And only when these things are not there, then you go in for ossification.
तो जो भी 18 साल के अंदर वो क्या करते हैं कि अगर मोच आ गई है, दाढ़ी आ गई है, तो फिर उसको 18 साल के ऊपर है और उसको लिख देते. अगर उसको पूछते हैं कि 18 साल के अंदर है, उनका काम बढ़ता है ज़्यादातर. इसके लिए वो फिर ये 18 साल के ऊपर दिखता है, डाल दो जेल में. बहुत सारे केसेस में ऐसे भी होता है.
Ramdev Chauhan is a case in point. It was a case of triple murder by a 14.5 years old. And the first court did get a medical board appointed. It did do the medical and said, according to the reports, he was certainly not, he was in the age group of 14 to 15. That was the medical report. That was his school register. And even then the judges said, no, this is not reliable. Some cross-examination took place and his age was determined to be 19 on the date of the offense. He was given death penalty by the first court. So after 18 years of this boy being in prison, we were finally able to get him out when finally the Assam High Court said, yes, he was 14 and 15 between the age of death.
A juvenile, they called me, but I wasn't treated like one. The khaki verdis, the black coats, an entire courtroom, all staring at me. I tried telling them it was my best friend, nothing more than an accident, but who was listening? Those psychologists? They weren't there for me. Pendencies, lawyers' fees, typing keys, but all I heard in return was guilty. I looked old enough to them. Why shouldn't I be punished? They dragged me away from my entire life, dumped me into a home away from home.
Psychologists are very rarely seen as a part of the juvenile justice system. And a lot of that has to do with organizations coming forward and saying that we'll be present here and we'll make sure that these services are created. However, this isn't something that the government has taken up as of now.
Supposing the state does not provide a prosecutor, does it mean that the NGO should provide a prosecutor? I don't think so. So really, it is for the state to make sure that psychologists or psychiatrists or counselors or whoever is required to assist the Juvenile Justice Board must be made available.
When it comes to counselors and counseling in the Juvenile Justice Board, there is no clear process that is standardized or followed by every single therapist.
There are no psychological assessments which are foolproof. which can tell you that, if you follow XYZ tests, it is bound to tell you whether the person has an adult-like mind or a child-like mind.
However, in the implementation of giving access to things such as counseling or therapy for these children, there are no clear allocation of funds that happen or clear vacancies that have been created for these processes.
The fund allocation is essentially for those who can be reformed and to give them some training. And the budget is, in fact, quite substantially larger than before.
गवर्नमेंट का फंड जो है वो नहीं है ज़्यादातर, अगर होता भी है तो अमाउंट थोड़ा होता है, इतने सारे फॉर्मेलिटी होती है कि हमारा साल खत्म हो जाता है तो पैसा भी नहीं आता है जल्दी.
Yes, there is a fund, but we are not aware of that at all. And in the past 2 years, which I have been a member, we have not been given any information on the provision of such fund, and nor have we utilized it.
Well, there was supposed to be juvenile justice funds set up by every state and union territory. There's nothing from the central government. The central government expected that each state would collect the necessary money. Estimates were in the neighborhood of 50 crores per state. But some states have barely 10 lakhs, and of the 10 lakhs, in one particular state, I'm told they'd only spent 1 lakh. So it's not as if it's a serious money being spent.
Even with minimalistic investment, we have actually been able to bring down recidivism. Doesn't that speak for itself? So if we were actually to make enough investment and really work on reforming these young boys, we could achieve wonders.
The juveniles accused of committing petty or serious offences are sent to observation homes, and if convicted, are then sent to remand homes. And those juveniles of 16 to 18 accused or convicted of heinous offences are sent to a place of safety.
No, place of safety is an alternative to, instead of
heinous offences are sent to a place
and really work to
are sent to observation
achieve wonders.
The juveniles accused of committing accused of committing petty or serious offences are sent to observation homes. The juveniles accused of committing petty or serious offences are sent to observation homes, and if convicted, are then sent to remand homes. And those juveniles of 16 to 18 accused or convicted of heinous offences are sent to a place of safety.
No, place of safety is an alternative to, instead of being sent to a regular jail, it's like a halfway house, that they are kept there and so that they are not suddenly sent into a harsh milieu.
I call it a magical place under this legislation, which will cater to everybody's need, which will be making everybody reformed. Then all this radical element and the murders and the rapists and all the serious offenders will come together and they will be reformed. I don't understand the whole approach of the legislation.
Most part of the country, place of safety do not exist. So there are ad hoc arrangements being made, Sometimes some part of a jail is designated as a place of safety. Sometimes some part of an already running observation home, a place of safety. For example, one room in an observation home will be designated as a place of safety.
These particular institutions have to be up to the mark. And as the rules
may have a primary in that empty classroom.
So when you decide alcohol is available, every second day there is escape happening. So where is the reform?
A 17-year-old boy who was arrested for theft has died in juvenile custody after allegedly being brutally assaulted by his fellow inmates. In his dying declaration, the boy, who named two of them, as well as the warden of a juvenile home in Matunga.
The situations are bad enough that sometimes these children prefer going back to their situations than living in that shelter care.
They're good for taking care of the child while the child is in the institution, if the institution is providing for what it's supposed to. The child while the child is over the child to the family do not make.
The main thing what I want to show you was, so what have you understood from that aspect? Can anyone tell me? Can anyone tell me what have you understood from there? What have you understood? So what have you understood from there? Anyone? Okay, what I was trying to convey was that a juvenile is a very important factor where it have a various process of a student to be reformed, and especially what you have seen 2015 acts. Now the 2015 acts have come up from 16 to 18 years to treat as adults as heinous crime. So for petty offences, it is up to 3 years. For the serious offences, it is up to 3 to 7 years. And now we have seen is that for a heinous crime, like in terms of murders, now it have increased up to 16 to 7 years and beyond. So this is the idea that how the from the one shelter home it is transferred to another home. So these guidance comes through a very multi-layered process, so multifaceted process. So this has been transformed and try to understand that how these have a various connotations to it. Whether we take in terms of the Nirbhaya case, so are they the adult, or how to treat as them? It's a rape, a very heinous crime. So these are the certain examples that a juvenile justice or a youth have to be understood. So today what I wanted to show you was mainly how the traditional law and justice is provided, like the three pillars of society: traditional law and justice. And traditional law encompasses the generation, and it provides continuity to maintain order. And the justice creates for the fair process and equitable outcomes, procedures and substantive dimensions, substantive equitable outcomes, substantive dimensions, procedural fair process, impartiality, equity, and the concept of dharma, especially how the concept of dharma reflects in terms of the dharmatic thing. So whether we talk about the child labor and women, how the urban realities, the rural context, and legal response is suspect, and key legislation for women when we talk about the Domestic Violence Act 2005 and the Maternity Benefits Act, or the Dowry Prohibition Act 1961, Domestic Violence Act 2005, and then the recent thing which have come is 2013, the Workplace Harassment Act. So inheritance and divorce inheritance law, the Indian Succession Act 1925, and divorce law have still been used by the Hindu Marriage Act and the Surrogate Application Act. So justice laws in India, which we have seen into the justice for youth. So these are the things which we have to give concerns the important aspect. So I hope I will send you the materials and try to go through it properly, and I will see you in the next class in 5 minutes. Let's see. Let's meet together in 5 minutes again. Okay.